Hello everyone, my name is Kamal Chauhan. I'm a regulatory partner here at HCR, and today I'm going to take you through my regulatory essentials for in-house lawyers. So I'm going to cover three parts of my review, and of course 2020 and going into 2021 has been an unprecedented year for all the wrong reasons. However, at last we have taken the first tentative steps on the government's lockdown roadmap, and during this time the regulators have been making strides too. For example, the HSE has bolstered its ability to carry out more inspections on site through hiring private firms, which is the first time it's done so in its history. And from the 1st of April 2021, the Food Standards Agency will be advising businesses to remove CBD products which do not meet safety criteria for novel food regulations from sale in what some see as a crackdown on a lucrative CBD market. So in part one, I'll be covering Covid-19 and what I think health and safety management in businesses will look like. Part two, I'll quickly talk through my observations on vaccination and health and safety management. And part three, we'll be looking at a couple of cases that have been in the courts during this pandemic time. So let's start with part one. In terms of legal duties, some things don't change in the time of pandemic. So whether working at home or in the office, employers are under a legal duty to ensure their employees and visitors' health, safety and welfare is protected. Notwithstanding the fact that this is a disease that is prevalent in a community, employers must still take action to ensure adequate control measures are in place to guard against risk of transmission. To understand the legal duties imposed by COVID, it's important to consider the mechanisms on transmission. Transmission is primarily airborne, of course, through face-to-face contact, and a virus may be suspended in air as aerosols for appreciable periods of time, and transmission is significantly greater in enclosed spaces. The global strategy has been one of limiting person-to-person contact, either through complete reduction in social contact or through social distancing. Also, public health messaging has emphasised hygiene, particularly washing hands on a regular basis and cleaning and disinfection of contact surfaces. As we see restrictions being eased, offering us all a route back to some sort of normality, this inevitably leads us to returning back to our workplaces and within our businesses. As in-house teams, your tactical response may have been to put in place site-specific COVID-19 risk assessments, and certainly in the short term, it would seem wise that some of these measures in these risk assessments do remain in place. Inevitably, businesses will need to resharpen their risk assessments and their safe systems of work. The Health and Safety Executive has been busy in this regard by conducting spot checks and inspections on all types of businesses. It's also working with trained and approved partners to ensure that they can visit as many workplaces as possible. Several clients have received such visits, and a range of sectors and recent conversations with two HSE inspectors have confirmed that they are spending almost all of their time on COVID-related matters. So when visiting, the HSE will want to see your workplace risk assessment, and they'll also inspect the adequacy of the hygiene practices and social distancing requirements and measures that you have in place. Perhaps more importantly, they'll speak to your staff and observe them to confirm compliance or lack thereof. Are you confident that you'll know what your staff will say about the adequacy of the measures in place? As in-house counsel, are you ensuring that only those staff that need to be in a workplace are there and you're not over capacity with regard to your risk assessment? Answers to all of those questions will determine the HSE's next steps, which could include enforcement. On the whole, of course, employers will be doing their best to comply, and as in-house advisors, I'm sure that's what you'll be doing too. However, regardless of the number of control measures that have been implemented, having to deal with the authorities scrutinising your systems and documents is yet another unwelcome distraction at what is already a very difficult time. So in this regard, there are likely to be positive and negative implications of COVID-19. So what does this mean for you as in-house counsel and risk managers for your businesses? COVID has been a distraction, of course. Some workplaces seem to be focused on COVID risk at the expense of general safety. This is in part because COVID-19 has reduced the capacity of frontline workers and management to focus on day-to-day safety concerns. While there is no data as yet, the impression is that safety standards have slipped back. Reduced human resource on the sites has led to reduction in focus on general safety in the workplace, resulting in reduced compliance in certain instances. Additionally, there have been fewer competent people at the workplace, either through illness or due to efforts to limit the numbers of people for reasons of social distancing in certain sectors. There is an unknown impact on general well-being of the workforce. Frontline staff who may have worked through the peak of the lockdown are working under time pressures with reduced resource in a high-risk environment, with the added pressure of Covid-19 in working life. This combination of factors may well have a bearing on long-term mental health, especially in sectors where this is already an issue. But there are, of course, positives, and despite the challenges of Covid-19, there have been benefits for safety. The need to adapt has generated a readiness to change. Many sectors have been able to respond rapidly to health and safety related change, and thus have demonstrated to both management and frontline staff what is achievable when priority is given to health and safety. This experience may well benefit safety promotion in the future. Furthermore, COVID has presented an opportunity to emphasise the importance of more general hygiene practices as a major consideration of all sectors. The need to redesign work and processes in light of COVID guidance has also presented an opportunity to more general work redesign to improve safety. In particular, thinking of the hierarchy of controls and your role as in-house counsel, COVID has provided an impetus to think more about the circumstances where people can be kept at distance from dangerous equipment or activities to reduce risk. Safer behaviours have been developed by safety managers or supervisors, but COVID has also generated some ad hoc behaviours that can be further developed by the workforce. I mentioned at the very start that the Health and Safety Executive has awarded 2 contracts to firms worth around £7 million. The firms have been hired to carry out spot checks to workplaces, and this has enabled the HSE to focus on more complex COVID work alongside its investigation responsibilities. The contracts have been awarded after a decade-long decline in the HSE's budget, which has seen inspector numbers drop from around 1,300 in 2010 to around 1,000 in 2020. The HSE has been inundated with COVID-related safety complaints during the pandemic, and it's dealt with at least 100,000 COVID cases, with nearly 25,000 complaints coming from workers and the public in January alone. At the start of the pandemic last year, the HSE said it was ready to shut businesses down in extreme situations, but thus far not one company has been prosecuted for a COVID-related breach. So you would expect to see enforcement action being taken when there are no or very little control measures in place. Figures released by Public Health England at the end of February 2021 show that there have been 3,500 COVID-19 outbreaks in workplaces, including offices, factories and construction sites since July 2020. There were 100 outbreaks during the latter part of February 2021 alone, despite the country still being in lockdown, with only essential workers supposed to be travelling to work. Around 14,000 people of working age have died with COVID-19 related issues, which is 12% of the overall death toll. This does suggest that despite having an opportunity to reclassify COVID, the HSE has still not grasped that COVID-19 in a workplace is a real risk. Perhaps this is indicative of the underlying fact that the HSE are regulators of at-work risks to health and safety and not of global pandemics that do not differentiate between work and general society. There is no requirement for incidents of disease or death of members of the public or patients at care homes or service users from COVID-19 to be reported, which has led to a systematic underestimation of COVID-19, and therefore they may well have missed out on vital opportunities to investigate and learn lessons to prevent further disease. Likewise, it has not allowed the HSE to see the true extent of the issue and to act accordingly. So how is this relevant to you as in-house counsel? We have seen companies issued with enforcement action, even though they have introduced and implemented a risk assessment, social distancing measures, signage, temperature screening, information, and availability of hand sanitizers. You will need to assess whether enforcement action could be likely in your businesses on the basis that there had been a failure to fully consider and control risks. Such enforcement action can be by way of notice of contravention, identifying a material breach, a prohibition notice, or some sort of improvement notice requiring you to take action within a certain time period. The HSE has maintained the position that it will be prosecuting where appropriate, but it has stressed that it's facilitating swift responses by employers through direct persuasion, advice, and reprimand, not through slower proceedings. Prosecution is reserved for the most serious breaches, and As yet, we are not aware of any COVID-specific prosecutions. However, it's very likely that the HCA will investigate those businesses where very little has been done to control and mitigate COVID risks, as this could be seen as indicative to having poor health and safety policies and procedures in place. So in the second part, we're going to look at vaccinations and how this impacts health and safety management and where you as in-house lawyers may be able to assist your businesses. Each employer needs to consider the risk to staff and others from transmission of the virus and which risk management controls will minimise those risks. One of the control measures may be your risk assessment. Another of those controls may be vaccination. Of course, while some will see vaccination as a silver bullet, it may not be welcomed by everyone. Your function as in-house counsel, if your business's risk assessment is undertaken properly, there may well be environments where vaccination is mandatory and it becomes a condition of obtaining or retaining a job. For example, because customers require it, which is likely to be the position for care homes, and we'll come on to that very topic in a moment. In terms of justification for mandating the vaccine, there is a huge difference in terms of the risks to or from someone not vaccinated who works on their own outside, for example, and to those who work in close proximity with vulnerable people, such as those in a care home. Alternatively, control measures may mean that vaccination requirement cannot be justified on health and safety grounds because of the adoption of other measures which can adequately manage the risk of virus transmission to individuals refusing the vaccine. Alternative controls will continue to be relevant, as there will be a number of people who, for good medical reasons, cannot have the vaccine or who remain unable to obtain one. It's also unclear at present whether we will have to move into a cycle of regular booster jabs to manage variants of the virus. So there are likely to be many challenges for in-house teams when considering vaccination of the workforce. There has been a significant amount written about whether employers can force vaccinations on employees, and no doubt you as in-house counsel have been active in advising your stakeholders in businesses. However, from a regulatory point of view, there's been a strong indication from a recent employment tribunal case that employers will be supported with the imposition of reasonable controls, including vaccinations. An interesting question therefore arises: where an employee refuses to be vaccinated, how can you still demonstrate as a business that you have taken all reasonably practicable measures to ensure the health and safety of your staff and others? In such cases, you will need to remind yourselves of the fundamentals of health and safety in a workplace and to be prepared to demonstrate how this has been achieved where vaccinations have not been fully taken up by your staff. If vaccination is necessary, then the health and safety control measures required for the health and safety of staff or others may be impacted by your undertaking and may allow the dismissal of, say for example, an anti-vaxxer to be considered reasonable. There are clear health and safety requirements to protect workers who come into contact with infectious microorganisms in the course of their work. Where there are indirect health and safety concerns, it is again important to use principles of risk assessment as a basis for ensuring the appropriate controls are put in place. So while the introduction of the vaccine is a very positive development, it's critical that it's not as yet the first line of defence against COVID for now, nor will it be for some time to come. However, all the preventative measures you have had in place for some time are equally important now, and perhaps more so when the vaccine is administered widespread. If mandatory vaccination is a position that your business adopts, following your advice, your team needs to be able to defend the business position on health and safety grounds that will be a question of fact and degree. In-house lawyers will be acutely aware that mandatory vaccines may give rise to employment tribunal claims. Given that legal costs are not normally awarded in an employment tribunal, rather than being right but out of pocket because of your claim following dismissal, the more pragmatic approach may be to ensure that the risk assessment itself is objective and realistic and looks at the risks and risk controls possible and necessary, and engage with those who don't wish to be vaccinated to identify if there's a legitimate reason behind the refusal to be vaccinated, and to help them understand why it's important to have those control measures in place and what the implications may be of their refusal and how this will impact the business. Reminding them of their statutory duties under Section 7 of the Health and Safety at Work Act 1974, for which there are criminal sanctions for a breach, which include prison and fines, might also help you to persuade them to your viewpoint, and it may assist you in resolving the issue without descending into litigation. So finally, in part 3, I'm going to look at a couple of cases that have been quite important in my opinion and may assist you in your practices. There are two cases in particular. The first case is Cubilis versus Kent Foods Limited, and this was heard on the 10th of February 2021 in East London Employment Tribunals. I anticipate that this is a case of significant importance to you. The claimant, Mr. Cubilis, worked as a Class 1 driver for a distribution company which transports food products from suppliers to customers. The tribunal was told that the company considered a good relationship with clients and suppliers to be essential and paramount it to being a success. It instructed its employees via its employee handbook that, in quotes, they should be courteous and pleasant to clients, suppliers at all times. Rudeness or offhand treatment of clients or suppliers will not be tolerated, however badly the client or supplier may have behaved. The handbook also warned that employees should take all reasonable steps to safeguard their own health and safety and that of any person who may be affected by their actions at work. Most significantly, for the case at issue, it stated that customer instruction regarding PPE requirements must be followed. So let's look at the detail of the case. At some point prior to 21st of May 2020, the tribunal was told that Tate & Lyle, a major client of the company, took the decision that face masks should always be worn at the site by all staff as a safety precaution to reduce the risk of corona infection spreading. All visitors to the site were issued with face masks at the gatehouse. The claimant was seen in his cab without a face mask, although he had worn a mask when working outside of the vehicle. He refused a request to put the mask on, claiming later that "my cab is my home. When I leave my cab, I wear a mask, and it's not the law." However, he was banned from returning to the site and subsequently dismissed by the company on grounds that a deliberate refusal to comply with a health and safety instruction was a serious breach. The driver's lack of remorse in his disciplinary hearing was also an important factor, so said his site manager. Well, the tribunal decided that a reasonable employer might have concluded that this instance of misconduct merited a warning rather than summary dismissal. However, it recognised that the driver's continued insistence that he had done nothing wrong had caused his site manager to reasonably lose confidence in his ability to work with clients. The tribunal ruled that the dismissal was fair in circumstances in which an employee refused to comply with a customer's requirement, even though it went beyond that required by law. In other words, that he wears a face mask inside his cab when making a delivery. This led to him being banned from a customer site, which made his job untenable going forwards. So the tribunal's decision appears to have been based on the fact that an employer's decision to dismiss was reasonable when the employee breached the reasonable health and safety instruction to wear a mask, even though it went beyond what was required by law, a very important issue. Now, the second case I wish to refer to is not so much a COVID-related matter, but it deals with a very important regulatory principle of the reverse burden of proof, which will be important to those in-house teams whose businesses operate in a regulatory setting. In this case, prosecuted by the HSE, AH Limited and Mr. SJ, who's the director of AH Limited, are due to stand trial in a Crown Court on the 4th of October 2021 on charges arising out of the death of a resident at a nursing home in 2015, which is owned and operated by the company. The resident died as a result of serious burns to her legs, caused by scalding hot water entering the bath while she was being bathed by carers. Now, it's a prosecution's case that this death was entirely avoidable and would have been avoided if baths, showers and sinks in a care home had been fitted with thermostatic mixer valves, which are regularly checked, serviced and maintained. The bath where the resident received her fatal injuries was fitted with a TMV, but it was not the appropriate type, it had not been serviced, and it was found to be defective. Additionally, the staff working at the home were not given adequate training or oversight to ensure that they cared for residents in a safe way. On the 28th of April 2020, both applicants pleaded not guilty to all the counts in which they were charged. The matter was listed for a case management hearing on the 18th of January 2021 at the Central Criminal Court. The parties made a joint application at the outset for the judge to give a ruling as to where the burden of proof lies with regards to reasonable practicability under Section 40 of the 1974 Act. The prosecution advanced that it lies with the defendant, and the defendants argued conversely that it was no longer proportionate for a defendant in health and safety matters to prove their innocence. The judge, after hearing oral submissions, handed down a written ruling on the 5th of February 2021, finding in favour of the prosecution's submission that defendants have to continue to demonstrate in health and safety matters at least that they had taken all reasonably practicable measures, i.e. the reverse burden of proof. Permission to appeal the ruling on the point of reverse burden of proof was heard in the Court of Appeal. Now, in true criminal matters and true criminal offences, the usual principle is that the prosecution should prove their issue beyond all reasonable doubt. And if there's any doubt, the defendant ought to be acquitted. In regulatory criminal offences, it shall be for the defendant to prove that it was not reasonably practicable to do more than what was in fact done to satisfy the duty or the requirement. Under the reverse burden, the jury might doubt that it was reasonably practicable for the defendant to do more, but perversely, some may say it may convict the defendant because he had not satisfied them that he could not have done any more. In this instance, the defence argue that the reverse burden of proof therefore creates an unfairness. Surely a defendant should receive the benefit of doubt, as allowing the innocent to go free does not undermine the regulatory regime. The Court of Appeal refused permission to appeal from the clear and carefully reasoned ruling of the Crown Court. In their view, there is nothing disproportionate in a reverse burden of proof imposed on defendants by Section 40 of the Health and Safety at Work Act. In other words, in regulatory criminal matters, it's still the case that a defendant has to prove their innocence and demonstrate that they could not have done anything further or reasonably more than what was actually done. So finally, actions for you to implement. Well, Covid-19 has been a virus that we all need to work alongside for some time to come. So my advice and my observations would be to implement a Covid-19 risk management system within your pre-existing risk management, engage with the workforce to design out risk, and implement a robust health and safety measures. For those who are active in acquisitions, ensure good due diligence, and of course remember, breaches are criminal offences and innocence does not necessarily relieve you from the reverse burden of proof. Many thanks. If you do have any questions, please do get in contact with us.